Welcome to Breaking News TV 24, your channel for news updates and current affairs. Stay tuned.
Breaking news, Justin. Kano State Governor files appeal challenging election tribunal judgment. For details of the story and the other important things you need to know about this, stay tuned. The Governor of Kano State, Abba Kabir Yusuf, has filed a notice of appeal challenging the judgment of the governorship election petition tribunal sacking him as governor. The tribunal ruled that the candidate of the opposition party, All Progressive Congress APC, Nasir Yusuf Gawuna, was the winner of the 18th March election 2023. Mr. Yusuf, through his party, the New Nigeria People's Party NNPP, in the appeal number EPT/KN/GOV/01/2023 dated 2nd October said he is not satisfied with the tribunal judgment delivered on 20th September 2023. He therefore asked the Court of Appeal to set aside the judgment of the tribunal because the tribunal erred by delivering the judgment virtually, which violates the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended. In the notice, the governor argued that the tribunal, being a creation of the Constitution, is bound to obey every provision of the Constitution. It is mandatory for the tribunal to deliver its judgment in the open court in Kano, where all hearings and the proceedings took place. The judgment was not delivered in the open court in Kano, where the hearing notice ordered parties to attend or assemble. The obligation to obey Section 36, subsection 3 of the Constitution of the Federal Republic of Nigeria is not excusable under any circumstances. The judgment delivered via Zoom platform is in violation of the Constitution and is null and void, the governor argued in his first ground in the appeal notice. However, a Premium Times newspaper reported how the tribunal sacked Mr. Yusuf after deducting 165,616 votes from the total votes he scored during the election. The three-member panel of judges ruled that the ballots containing the votes were not certified by the Independent National Electoral Commission, INEC. The tribunal said the petitioner, the APC, had proven the allegation of the invalidity of some of the votes cast on the ground that the election was not in compliance with the provision of the Electoral Act 2022. The tribunal therefore ordered that the invalid votes scored by Mr. Yusuf be expunged from the total votes he scored. The tribunal then ordered INEC to retrieve the certificate of return earlier issued to Mr. Yusuf and present it to the APC candidate, Mr. Gawuna. Another issue is the notice of appeal. In ground 18 in the notice of appeal, the governor argued that the tribunal erred when it relied on Section 71 and Section 63 of the Electoral Act 2022 to nullify the 165,616 ballot papers returned in favor of the appellant, Mr. Yusuf, and wrongly declared Mr. Gawuna as the winner of the election. However, in ground 19, Mr. Yusuf said the tribunal erred in the law when it relied on Exhibit 95, P6-P16C and P18-934A, which are ballot papers of unknown polling units, to reach to conclusion. The governor also said the respondent, which is APC, did not plead with the polling units where the alleged invalid papers or ballot papers were used, and the tribunal was therefore wrong to accede to cancel the lawful votes. There was no witness presented by the first respondent to testify as to use of any of the ballot papers in any polling unit. The tribunal did not demonstrate in its judgment how it arrived at its decision on 165,616 invalid votes against the appellant and its candidate, which is Mr. Abba Kabir Yusuf. It is not the duty of the tribunal to make a case for the first respondent or petitioner. The petitioner pleaded a total of 841,228 votes by the combined reading of the paragraphs 92, 93, and 95 of its petition. It alleged unlawful ballot papers in 32 local governments. There is no evidence to prove this, and there is no evidence to show the tribunal dramatically came down to figure that the tribunal picked on its own, the governor argued. The governor also argued in ground 20 that the tribunal misdirected itself when it went out of the judicial duties by constituting itself into witnesses and investigators and sat as judges. The tribunal was wrong when it declared Mr. Gowna as the winner of the governorship election after deducting 165,616 votes from the lawful votes of the appellant and its candidate, and without confirming whether he satisfied Section 179, subsection 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, and therefore occasioned a grave miscarriage of justice, the governor argued in his ground 22. However, the decision is unjustifiable and a gross miscarriage of justice, in that the tribunal based its decision on the wrong application of the laws. The tribunal's decision is based on the tribunal's replacement of its opinion for the evidence on record and the refusal to consider evidence on record that is favorable to the appellant and its candidate, thereby causing manifest injustice and the denial of a fair hearing. The tribunal's decision is perverse and has occasioned a grave miscarriage of justice, in that there is no pleading and the evidence that the first respondent's candidate scored 1/4 of votes in 2/3 of the 44 local governments in Kano State as mandatorily required by Section 179, subsection 2 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The statement of the tribunal that it is determined that the petitioner, who is Nasir Yusuf Gowna, having scored a majority of lawful votes and having met the constitutional requirement, is hereby declared the winner of the election and returned elected as the governor of Kano State, is wrong and perverse, in that, obviously, that is not the petitioner before the tribunal. The governor argued that at the appeal court. With these grounds and others, the governor asked the appeal court to set aside the judgment of the tribunal delivered on 20th September and give an order affirming Mr. Abba Kabir Yusuf as the governor of Kano State. Thanks for being with us, and this marks the end of our story at the moment. But before then, we would like to hear your opinions and thoughts on this matter. Have a nice time and goodbye.